Article 51C is the sister provision to Article 51A. This deals with an award that covers a difference that isn't covered by the terms of submission to arbitration. It typically contains an award of something that the parties haven't claimed, or it fails to deal with something that the parties have claimed. In practice, this is an awkward provision for arbitrators. When faced with a claim that hasn't been properly drafted, that omits a head of claim that is very obvious, like interest, should the arbitrator nudge one of the parties? Should they tell them that actually this claim needs to be amended? It's probably a good idea, except in the situation where the arbitrator is well aware that both parties are equally well resourced. The arbitrator's function, after all, is primarily to do justice and not to play some form of game based on the parties' contract. At least that's my view. But there are different opinions on this subject. Sometimes the arbitrator gets hamstrung by a badly drafted claim, and I'm not sure that should happen. It doesn't seem to make a great deal of sense. Article 51C can be seen in some sense or another as the excess of jurisdiction provision, but it isn't one, and it doesn't really do that. The Lesotho Highlands case, which isn't strictly speaking on the New York Convention, raises the question of what is an excess of jurisdiction. In that case, the majority of the House of Lords, if you piece together the various judgments properly, reached the conclusion that if the arbitrator starts the case with jurisdiction and renders an award which is not excluded by the parties' agreement, then there isn't a problem with jurisdiction at all. That's a very different view to that taken by the US Supreme Court in Stolt-Nielsen, where the Supreme Court considered an arbitrator who didn't take into account properly the terms of the contract, or appeared not to consider them properly, was in fact exceeding jurisdiction. It's a view that is widely disagreed with in Europe, where the idea of denaturing a party's contract was rejected many years ago as not being a ground for setting aside or refusing enforcement to an award. 51D is the procedure provision. It generated a lot of excited discussion around the time of the New York Convention because it represented an attempt to get around the double bind contained in the Geneva Convention and Geneva Protocol. That double bind insisted that the arbitrator's procedure comply both with the procedural law and the parties' agreement. It's probably wise to get rid of the notion of procedural law now once and for all. In 1958, it probably meant rather more than it does now, because if one agreed to arbitrate under the procedures of a particular country, one was probably agreeing to the laws of evidence and quite a lot of the procedural rules of the local court system of that country. That is no longer the case in almost any modern arbitration country. The procedural law for an arbitration is contained in the Arbitration Act, and that typically says you've got to give each party a fair chance to present their case, and you mustn't breach the parties' agreement. And that's it. So in a funny sort of way, Article 51D has been brought back to the Geneva Convention simply by the disappearance of a notion of a procedural law as such. The problems will come, though, where the parties' agreement contradicts the law of the seat of arbitration. A good example of this might be an agreement to provide for full med-arb in England, Wales and Northern Ireland. Under the 1996 Arbitration Act, the parties cannot contract out of the right to a fair hearing. It's impossible to see how a fair hearing can be accomplished if the parties can privately speak to the arbitrator about matters which are then not subsequently disclosed to the other side. In that situation, you'd have a conflict. The main discussion about Article 51D concerned the Dutch provision of consolidation by local courts of arbitrations that concern similar subject matters. There was extensive discussion between Sigvard Jarvin and Albert Jan van den Berg about this, Albert Jan van den Berg having played a role in drafting the provision in question. Jarvin argued that an arbitration award rendered after a consolidated procedure would actually fail the enforcement test under Article 5.1d. The reason being that the composition of the arbitral authority or the arbitral procedure would not have been in accordance with the parties' agreement. The parties' agreement provided for arbitration only with their immediate contracting partner, not 3 or 4 other parties along the way. Van den Berg argued, successfully I think, that when you agree to arbitrate in Holland, you know perfectly well that there is court-ordered consolidation and your agreement is in effect subject to it. The Van den Berg argument, though, contains one interesting weakness, or perhaps it's a strength. The weakness is that it is undoing the intended change to the Geneva Convention that the ICC original draft, which was one of the inspirations for the convention, was designed to achieve. He was, in fact, restoring a very good provision of the Geneva Convention. Courts elsewhere, particularly in Europe, have taken a similar approach to Van den Berg in relation to the rather odd English arbitration rule, which says that if one party does not appoint an arbitrator, the party that has appointed an arbitrator may seek to have their nominee made into the sole arbitrator to resolve the dispute. There were a number of cases in the early days of the convention where it was argued that an award rendered by such a sole arbitrator breached Article 5.1d. With very few exceptions, that argument was rejected on the basis that parties who agree to arbitrate in England agree to that rather odd rule.